Good evening, ladies and gentlemen. Law Essentials welcomes you to the Lawyers as Peacemakers series. Today, we are delighted to have with us our guest panel, Ms. Jacqueline Horani. She is also known as Legally Unconventional. She is an attorney, entrepreneur, and consultant. She is licensed to practice law in New York and Nebraska. We also have with us Ms. Nabeela Siddiqui. She is currently a PhD scholar from Christ University, Delhi. We also have with us Mr. Ashit Kumar Srivastava. He is an assistant professor at the Dharmashastra National Law University, Jabalpur, Madhya Pradesh. Thank you so much all for joining here with us.
Thank
Thank
you
you.
so
I would
much.
request Nabeela ma'am to start off.
Yes, thank you so much, Farhan, for the quick introduction. So, this is an extension of the Integrative Law series, lecture series that we've planned. So, we had many lectures in the past which are dealing with unconventional forms of issues regarding law and their coherence and their practices, which the new breed of lawyers and academicians are trying to, propagate and also follow. Be it the way of drafting a contract or let's say even the basic implementation of laws, be it LGBTQ issues or as simple as the idea of plain language. So what we're discussing today is something which I think it has been of more let's say more of a intrusion rather than seen as something which should inherently be there. That is the idea of plain language. So today's topic that we have is the idea of plain language in drafting and interpretation. So to begin with, I'll speak for a lesser period of time because we have our experts on the topic, one from the academics and the other one who is practicing, and we're actually looking forward as a team to hear both of you. So I'll just give a quick narration or probably my own experiences and my understanding of plain language, and then we can go ahead with our speakers today on the floor. So recently in India, Jacqueline, as you might know, as you might not be aware, but then Ashit would have been, and the law students present here might have actually came to know about a judgment, which was very much in the news, and I think it was reported by almost all the leading forums. That was State Bank of India versus Ajay Kumar Sood, and it became a highlight for a very unpopular reason, and I'll say unpopular for the simple reason that Justice D.Y. Chandrachud very apparently and very in a very harsh tone, he pointed out the fact that judgments must be readable because judgments have an idea to furnish, they have a purpose to fulfill. They are not supposed to be sanctified and kept in a very let's say at a place which is at a sanctorum. It is something which should be given or published or be propagated to everyone and anyone, because judgments are the backbone of any legal structure, and so is judicial reasoning, where there has been a lot of scholarship on judicial reasoning and the functioning of, let's say, judicial institutions, but very less has been talked about the idea of language. Very less has been talked about the idea of you know good craftsmanship that is actually required while you are drafting, while you are narrating, while you are actually addressing the ideas of the both the plaintiff and the defendant. So this is something which needs to be discussed about. And when G.Y. Chandrachud pointed out this judgment, in this judgment of I think it was decided by a state court, that is Himachal Pradesh state. The High Court of Himachal Pradesh actually, in a very archaic manner, in a very flowery manner, in a manner which was not explainable, which was not readable, pointed out something which was as simple as relatable to Article 226. And Article 226, Jacqueline and other people might be aware, but Jacqueline, I'll just inform that 226 and 32 are two ways whereby you reach a court for any grievances, and their scope is immensible. I feel 226 has sometimes played a larger role than 32. These are the
Yes.
articles of the Indian Constitution. So 226 has a larger role to play than 32, because 226 deals with the state courts, while 32 goes for the Supreme or the apex court. So as simple as these things were not able to translate to the general public, where we know that the Indian law per se, in the section 2, clause 9 of the civil procedure, if I'm not wrong. If I might be a little bit wrong as far as the section is considered, but to my understanding and my little knowledge, section 2 clause 9 of CPC actually defines a judgment. And when we see the Indian text, or the Indian scholarship has defined a judgment to be something which is a basis of a decree or order. So when the whole structure of defining a judgment is very distorted, then it doesn't speaks for the decree or order which is supposed to be translated to anyone and everyone. And on this occasion, I think I would like to, I remember a quotation by Macaulay, and I would like to quote Macaulay here. So Macaulay, at some point of time, I think in the 1883, he comes up with the idea, and he says that the objective of codification, because all the laws which have actually traveled down time or have naturally followed their path were codified in some way or the other through traditions and some other ways, but they were codified and brought to the knowledge of general people. So Macaulay interestingly says that the objective of codification is to actually secure uniformity wherever it is plausible, wherever it is possible, wherever you can actually do it, and diversity wherever we must have it. Because, of course, there are different sections of the society. So, therefore, he says that uniformity wherever it is plausible or possible, and diversity wherever we can have it. But in all cases, certainty must be maintained. So, certainty is the backbone, according to Macaulay. And as far as the Indian judgments are considered, we see that any judgment for that matter are actually let's say a window, or let's say a means of understanding for different sections of the society. Now, what are these sections of the society? One could possibly be the parties to the case. The parties to the case could be one, stakeholders, which we are discussing here. Second could be the authorities, which are actually expected to, probably comply or bring into effect the particular judgment. The third class of people, or the third stakeholders, could be, let's say, appellate or revisional court, which actually defines or determines the legal validity at that point in time, or probably in a future prospect to come. And lastly, and that is the most ignored and the most, let's say, denied class of stakeholder, that is public at large. Because when laws come, they are supposed to cater to not only the stakeholders that are directly involved in the process, but someone who is at the periphery, but sometimes also it affects the, let's say, the core of the system, that is public at large. Because you and me should also understand a law which is being implemented, or let's say being made for our
Mm.
own goodwill. So that communication, which we say that communication is the key, should be understood. And India has had its own ups and downs as far as judgment writing is considered, and there have been judges who have criticized the writing of judgments, and there has been a lot of criticism on the judgments themselves for writing judgments which, are not conveyable. And if I were to point out one another incident from the past, that would be a famous case, Jacqueline, that is called as Subramaniam Swamy versus Union of India. I think Ashit, when he'll speak, he'll also make a reference to this. So Subramaniam Swamy
The
versus Union of
longest
India
paragraph.
is one. Yes, it's one important
Mm.
case where we see that Chief Justice Deepak Mishra
The
actually
longest
comes up
paragraph.
with the,
Yes.
yes, so the longest paragraph. So he uses
And
and 17 times.
without
That's the total count
without
without
any comma and
stopping,
yeah, without
without any
stop.
comma. So
Yes.
see, that's the
192
importance
words,
of
sorry.
language. 192 words, yes, with 17 ands. So that's how complex you can make up a language. That's the beauty, and that's the creativity, and that depends on the authorship. So to make a simple thing complex is easier, but to make a complex thing simpler is a tougher task. That requires acumen, and that requires a lot of good training. And here is one point which I would like to raise in the largest sense, if I can say, that the basic idea which should be thought about is the training of the judges, as basic as at the training level, where judges, or probably the judges to come, that is at the lower level or the higher level, should be specifically taught to make things simpler. But here, simpler doesn't mean that you'll omit some jargons which are famously used by legal language, because at the same time we have to respect, or let's say we have to pay allegiance to a specific terminologies in the legal language which are supposed to, which have their own utility. But at the same time we also need to understand that it should be readable by the general masses. So that's the point I would like to raise here, and just add a little bit part of it, and then we'll hear you out. The last point that I understood and that I face as a person when I read judgments is that there is something called as passive voice and active voice, and there has been a lot of let's say discrepancy as far as the use of passive voice and active voice is considered. So just to say that in a passive voice that he was acquitted by the judiciary, it could indirectly in an active voice be said as that the judiciary acquitted him. Here not are you only saving the number of words, but you're making it simpler and easy to absorb. So these are the few areas which I think we could, probably delve into, and I would love to hear both of you who will, actually look into the topic more clearly and more in a more refined manner. So I think we'll have Jacqueline first, and then we'll have Ashit. So that is how we can, go about. Thank you so much. Yes, Jacqueline, please continue.
Wonderful. Thank you, Nabeela. And Ashit, I can't wait to hear your commentary on this as well. And I think these are excellent, excellent points. So absolutely, that shareholder class that is most ignored is the public at large. And I think that is such a critical component of law and what the role of law in society is. To me, this goes back to not just the idea of plain language and why this is important, or how we teach this in law schools or as practicing attorneys or judges, but more so to the point of the power that we hold as lawyers, and what is the discrepancy of power between the public and those within the law. And what I mean by law is the legal profession. So I think, as we see in many countries, is that the role of lawyers is the holders of this knowledge and the interpreters of this knowledge. And there's a distinction between the public at large and those that are able to access that information. And that is what creates the transaction, the dependence, and the necessity of perpetuating the legal field and the legal system as we know it. But it is incredibly powerful if we shift the concept of who lawyers are, what the role of law and lawyers is, to be trusted advisors, counselors, to help counsel people, and not to be the secret holders of select information and interpreters so that the public can't understand unless you come to a lawyer and have them translate it for you on what this means. So when you were talking about the case where there's the 292 words paragraph with 17 ands or whatever that one is.
192 words.
192, yeah. Okay.
Words. Yeah.
So something like that is so common. And in the US also, our cases, there are some very famous, simple ones and also extremely complex ones. And the point of making a decision in the law, we need to be thinking about the public, because the public needs to understand what the law is so they can act in accordance. And if we keep continuing to write cases and decisions and judgments in a way that the general public cannot understand, then we are not upholding the role of law as the framework of society, because then it is only for the power enforcement of those who are lawyers and judges to determine when to put this out into the world and when to call people in and when to say somebody is in the wrong. Because if the public doesn't understand what the law is, there's no shifting of action. There's no change in the behavior of the public. And really, that's what we're trying to create with the law, is these are the agreed upon rules in society. This is how we behave and interact with each other. These are the standards we hold ourselves to. And so I think that aspect of power and the role of lawyers is also a very important part of the conversation of plain language. When it comes to plain language, I also want to note that I have a sort of different perspective than some other attorneys who work in the plain language area, which I think often plain language is seen as get down to the fewest number of words and put it in the simplest way possible. There is great value to taking a paragraph and running it through multiple times and seeing how can you make this more clearly understood. But I don't believe that the answer is always going to be the shortest, most direct, simplest, fewest number of words, because I believe that plain language includes critically the voice of the parties or the people who it is meant to be read by. So I do a lot of work in contracts, which are more private, that you're creating an agreement between two or more parties, and it's really meant to be seen by them. And maybe it'll be seen by the court if there's a conflict and then maybe a decision passed down. But I think there's a difference between the plain language drafting of that kind of agreement versus the plain language used in a decision. When a judge is handing down a decision, that plain language, the voice of the parties, is not the most important. It's the voice of all of the potential readers, that this has to be able to be interpreted. And Nabeela, you mentioned the key terms, like certain legalese terms we have that over the years have developed a very specific meaning. That can be a plain language way to say a term. And I think for people to understand in the general public, we just need to define it in the decision so that we're explaining this is we're using this term and this is what this term means. Because we need to make it accessible and understood both by the lawyers who have been trained in a paradigm and understand what those terms mean and how they connect to other cases, but we need to make sure to communicate that to the public at large. So when I'm creating contracts in this separate situation where I'm negotiating between parties, that's where the voice of those specific parties is so critical to me. So I draft contracts, some which are very minimalistic, very direct, very short and brief, because that is how those people communicate. And I have other contracts that are more flowery and flowing, because that is how the people express themselves and how they understand each other. And sometimes when we try to go to plain language, we miss nuance. We try so hard to simplify something that we're not capturing the essence of it. And sometimes it reminds me of poetry or writing literature, because there is such beauty and such concepts that are conveyed in a longer or more flowery sentence. And you can simplify it so that a person can follow along logically from point A to point B to point C and see what is being created. Or you can create that flowery sentence in a way that is convoluted and I have to hold many things in my mind and I'm struggling to understand how it connects. So that's how, to me, plain language is not inherently fewest number of words, most direct, simple communication, because I think it's important we don't lose that nuance. So I'd love to hear from you, Ashit.
Yes, so I can start, right? Thank you so much. It was a great intro to the topic we have today itself. So I totally agree with the perspective that Ms. Jacqueline has put forward, the idea of stakeholders, and I feel that a simple language judgment might bring the fourth stakeholder, that is the people at large, into the scenario. So if you have the petitioner, you have the respondent, you have the judges. Those are the three stakeholders. The fourth one is the public at large. So while seeing the plain language movement, I might give a very contrasting opinion, and that might seem I'm tilting towards it also, I'm against it also. So there are three underscoring elements to the idea of plain language movement. The first is the idea of lack of transatlantic ideology. and I'll explore that ideology perspective also. Second one is the idea of the idea of using law as a tool of operation, which is mostly to do regarding the contract laws, and why lengthy contracts or complex contracts are used as a tool of operation. And I think Ms. Jacqueline might be a little yes, right. And the third element is certainty of law and doctrine of waiver. So doctrine of waiver is something which we practice in India, that we do not have doctrine of waiver. So if I have a fundamental right, I cannot waive it. Unlike the American jurisprudence, where you can waive off your fundamental right, but that's not applicable in India. We do not have doctrine of waiver. So I'll go through these three elements, and hopefully I'll make sense to the perspective. So the first element is the lack of transatlantic ideology. And when I say that, I really mean that because we are following a common law tradition, and this is a third world country, though we are developing at a great rate, we cannot deny that. But our jurisprudence per se is an adopted jurisprudence from a foreign country. And it by default becomes reflective in our judgments also. So if, yes, so if by chance, if okay, I'll give you just one example. If I'm using the term dignity, so dignity is, as a term, is not something which I'll relate as a person coming from India per se, because we do not have this term in our vocabulary. This is something we have been borrowing from the European jurisprudence, because dignity is something we relate to Europe. But when I am writing dignity in my judgment, I need to interpret dignity also as to what dignity means. Unless and until I gave an elaborate definition of dignity, the people in India won't be able to understand what does dignity really means. If I ask a layman today, what do you understand by dignity? Oh, dignity is a qualification. I earn dignity. But that's not the meaning of dignity. Dignity is something we are born with. But to understand that perspective of dignity in a European sense, I need to interpret dignity in that perspective. So in the lack of a transatlantic ideology, when I say transatlantic, I mean in the lack of our own jurisprudence of legal methods, we are borrowing laws from somewhere else. And I might sound like a very localized guy, I'm not, but still, I'm trying to give a much more the core issue of the plain language movement in India, actually. So in absence of any ideology, you're borrowing something from outside, but you're required to interpret it. So if someone has read that case Swami 1, and this is a right to privacy judgment in India, it came out in 2017. That's 547 pages, not long. And I tell you why it's not long, because case Swami 2 is 1,463 pages. And Keshananda Bharti, which we called as the largest judgment, is 763 pages. We also had the Ram Janmabhoomi case, the M. Siddiqui judgment, which was 1,063 pages. These are not long judgments, by the way. These are just, I'm just telling you.
No one should have to read that much for one decision.
Understand me. I'm a constitutional law teacher. I teach that. So I have to read all of them. But what is the
Imagine students, teachers, and everyone reading that, Jacqueline.
That is what I was going to say. Me as a student, I'm finding it so hard. At one point, I'm trying to get hold of that lex, thinking that it is the important thing. And on the other hand, I'm finding it extremely difficult to understand as well and to read those long judgments.
That's from a student perspective. You should see it from my side. I need to read it.
So who is that written for? Like, where is the power being held in all of that?
So that's the idea I'm trying to clarify on this issue. So in absence of a transatlantic ideology of our own, when we are borrowing something from outside, the first 20 to 30 pages goes for explanation itself. So if I'm telling what is dignity, I'll take 30 pages to explain dignity. So if you pick up any judgment today which is related to dignity, and not only dignity is again a European term, pick up secularism, pick up any foreign term which has a great significance in the European culture. You bring that term in India, it has its own ideology. It has to be defined in Indian context, and it will require around 30 or 40 pages to define that first. Once it is defined, then you start the legal process. So your pages are not going. See, you need to understand that we do not have per se our own legal system. It was something which we have borrowed from somewhere out. So if we had increased our own jurisprudence of our own, we might not be requiring to define the terms, right? When you talk about plain language movement, it's not only about the idea of not using legal jargons. It's also about writing simple and small judgments, right? So that's one of the part of it. The problem is that because we're so dependent on the European culture or in even the American culture for defining certain rights, it takes them so much time and so much pages to just explain what does it mean, right? And then to adopt that into Indian context, that requires much more time. So that's bound to happen. That our judgments are going to be very long, right? If I'm using a term, Dharmashastra, Nabeela, do you know the term? Dharmashastra?
No, I'm not aware.
Alina?
Dharmanirakshata means dharma, matlab religion. It shouldn't
Okay, they
be
are all equal.
dependent on
Okay,
religion. Yeah,
nirpekshita. Yes,
It
yes, they are
means
all
it
equal.
means
equal.
yeah, or religious neutrality.
Yeah.
Religious neutrality, right? Or we can call it secularism.
Yes.
We have
Yes,
a
yes,
term for
yes.
that, but we have adopted a European term, secularism. Now, secularism has a different context in European culture. When you bring that term into Indian context, it has to be
The
defined in
idea
a
of
different
church
manner.
and everything is there. Yes, yes,
Yes,
yes.
yes. You cannot. So there was no such warfare of the church and the king in India. That never happened. Right? We never had a social revolution. We just adopted a constitution. So, and that brings a big change in our movement. So our judges are trying to do the best. It's not their fault. It's no one's fault because we got a constitution. Our constitution was very alien to us. We're trying to adopt that constitution to our culture now. When we're trying to do that, we need to explain the term's meaning also. What does the term really mean? Secularism had different meaning. It has positive connotation. It has negative connotation. There is the idea of non-interference for the secular state. And there's theology also coming into existence. How do you define all this stuff? It's going to require a lot of time, a lot of patience, right? And that's why the judgments are way too long. That's one theory which I have regarding this, that why our judgments are so too long, because there's a lack of transatlantic ideology of our own, right?
But do you believe that it requires like 30 pages to define one word? Because I could see you spending a page to convey, I mean, an entire page to convey the meaning of it. You don't need to convey all of the history of things. You can have a simpler understanding, I would think.
I actually have your email ID. I'll share all the judgments with you. Second of all, it's not one judge sharing his idea about the term. You have a multiverse bench sitting with multiverse judges. They're giving their own interpretation. Each one giving his 30 or 25 pages opinion as to what the term really means. Then we go with the majority opinion. Okay, what majority? We just agree with the majority. That's the rule of law. Then the concurring opinion becomes the majority after 20 years. Now we are following that. After 10 more years, the dissenting becomes the majority. Now we are following that. So this is a little complex to tell. Now, I also believe it also depends on the kind of judges that are sitting in the bench upon the length of the judgment. Some of our judges have studied outside, so the kind of terminologies they are using, the kind of legal jargon they are using are not very how can I say, not very Indian in nature. We heard a term of constitutional morality coming into existence in 2018. Now we heard this term by Dr. B.R. Ambedkar in 1948. Now we are listening to this term right now after 60 years. So this creates a lot of right. So that's the first theory which I'm talking about. There's a lack of transatlantic ideology which is pushing for more pages for interpretation, and still not very sure. Even if I had to ask someone what do you understand by federalism, no one can answer that question at all. Right. That's the first theory. The second theory which I was talking about is the idea of law as a tool of oppression. So yes, and this is something related to the idea of legal jargons, right? So as we all know that a lot of Indian population is not really literate. Even if they're literate, they do not understand the idea of consent very well. So to consent to a particular topic requires a lot of free will, and in our social structure that's not really possible. We have our own bondages in every sector. I cannot explain it in a live class, but yes. So what happens when you use law as a tool of oppression? And as someone who is drafting contract must be knowing it, how the contracts are drafted to ensure that the other person just falls into the trap of it, right? And the usage of legal jargons becomes important there. You know what? You have read the term, they're not an issue. You have agreed to the agreement, just sign it there, there's no problem at all. And then you are bound by the standard agreement. Now, the legal jargons are used there. One of my friends, and this is like 3 years ago, she didn't know the term what does bona fide means. And she signed a contract. Now, bona fide is something a very universal term right now. I'm just trying to tell you something. How this is one small example. There are several legal jargons which don't know the meaning of, and even I'm not aware of them still, right? And we just sign to it, right? So I think sometimes the plain language movement is also the idea of respecting the consent of the other individual. That you want the simple language, just read it out, and you all would understand. They're consenting the same thing on the same part. There's a consensus ad idem, but that's not what's happening. We are purposefully using terminologies to ensure that we are able to take away the consent of the other person. Once that is done, we rule you, and our system helps in doing that.
This happens here as well, the same thing though, because the traditional legal process when parties, even if it's your own client, I have seen where the lawyers just say, oh yeah, this says this, just sign here. And they say, oh, okay. And they sign and they don't understand really what commitment am I making? What are the consequences? What is going to happen? What is the relationship between me and whoever's on the other side of the contract? And it's a very big problem.
Right. Again, so the intention of the lawyer becomes very important here. What is his intent? And his intent is money making. So, right. You cannot deny that, right? Right. The third element I'm talking about was the idea of solidity of law and doctrine of waiver. And to understand that particular doctrine, which I'm trying to emphasize upon, is we need to go back to the story told by Lon Fuller, right? Again, I'm using a European context to explain something into native language. We are dependent so much, right? So Lon Fuller has told the story of Rex, and I guess everyone has read the story of Rex, the King Rex. And this is a famous story in his book which he wrote, The Morality of Law. Lon Fuller wrote this book, The Morality of Law. This book was against the premise of Attlee Hart, the concept of law. Now, Lon Fuller, while writing this book, he writes a story there, the story of King Rex. Now, the great thing about King Rex is King Rex has made law, and the story tells us something. It tells us how a king would fail 8 times making a law. So, what are the 8 things one should not do while making a law? That's a summary of the story. What one should not do while making a law. One of the elements of those was that there should be certainty of law. The law should be certain for application. As Ms. Jacqueline has already emphasized upon this idea, there should be certainty of law. And I tell you why this becomes very important for India. Because in India, we do not practice doctrine of waiver. In India, we do not practice doctrine of waiver. So I'll give you one example. In 2017, we recognized right to privacy as a part of fundamental right. Okay. What does doctrine of waiver says? You cannot waive your fundamental rights. That's a simple idea. Okay. Do we have a consensus upon that? What does doctrine of waiver means? You cannot waive your fundamental rights. That's a plain meaning of doctrine of waiver. 2017, we recognized right to privacy. We also recognize informational privacy as a part of privacy. So even informational privacy is part of my right to privacy right now. It's a part of my fundamental right. 2017, okay. How many of you are still using Facebook, still using Twitter, still using WhatsApp, right? You have informational privacy. And as per doctrine of waiver, you cannot waive your fundamental rights. But you're still going on Facebook, you're still clicking on I agree button, it's still going there. Does that mean that I'm waiving my informational privacy? And if that is happening, this next question comes up. Was I notified that I have informational privacy? The court will say, yes, you were notified. Why? How? We wrote a 547-page judgment. Oh, where? Case put from you one? Oh, yes, you did. So there's a problem, right? It's a lengthy judgment. You need to find out that under page number 268, para number I'm forgetting right now, you have mentioned that informational privacy is a part of fundamental right. So by default, I'm still going on Facebook every day. By the way, I am violating Dr. waiver every day, right? So that's the third element I'm talking about. You need to ensure that if you get a right, at least aware people of the right, because Supreme Court judgment itself is notification that you got a new right to yourself. The problem is you need to read that also. And all these commercial lawyers, I'm sorry, all these commercial lawyers won't tell you what right do you have unless and until they're fighting your case. So, right. So these are the three things I really feel that why, right, informational, why plain language movement is a good option. But I totally agree with Ms. Jacqueline when she told us that certain things require more elegance, certain things requires more lengthy words, which we cannot deny at all. We do not recognize right to die in Indian Constitution. We had a very famous case, Piratiram, right, Nabeela?
Yes,
Yeah,
Ratinam. And then
Piratiram.
after that, Aruna Shawbang,
Yes,
yes, later.
Aruna Shonabag, where we recognize passive euthanasia. And those judgments really required a lot of judicial creativity as well as
Yes.
great elegant writing to ensure that we
Hmm.
can recognize passive euthanasia. So there is a
Yes.
positive side to it. But you
Hmm.
need to ensure that there is awareness also to the people that you know what
True,
you're getting
true,
some
true.
right to yourself. Even today,
Hmm.
people are asking how do we apply passive euthanasia in India?
Even
While there is
LGBTQ for that matter, I
yes,
think the issue. Yes.
yes. So and the judgment of Aruna Shambhag, the common cause judgment 2005, which said that we have passive euthanasia right. It has laid down the guidelines for it, how to follow it. But the problem is, it's such a
Hmm.
very lengthy judgment to read about it.
Hmm.
Right? Right? Then again, you need to see one more thing from a political scientist perspective. So creating a power structure in the hands of few elite people,
Yeah.
people who are
Hmm.
reading the judgment, people like me.
Hmm.
But I'm using it for a good purpose. The people who are
Hmm.
not good people, they're reading the judgment, they know the law, they know the rules and regulation, how to mold it. And you're creating a power structure by that.
Hmm.
So you need to realize that fact also. Right?
There's
And
also one point I'll just point it out here. Okay, Jacqueline, if you want to go first, yes, please.
I was
Please,
just
please
going
go
to
ahead.
say, I was just going to say to that point of that power structure, if we shift towards making it so more people understand the law, then we are able to help challenge that and equalize the balance of power in a society.
Right.
Nabeela.
Yeah,
I
actually,
agree.
what I understood from what Ashit is trying to say is that we've been actually adopting something called as cross fertilization. So we've been that bee who actually goes on to a lot of flowers and try to pick up a lot of pollen grains, and then actually fertilizing a flower which is very beautiful in its own sense. It's very peculiar, it's very unique, but then it has some attributes which are contributive of all the structures. So it's an assimilation. That's what he's trying to say. But then there's one problem here. Jacqueline and Ashit, both of you, if we were to read criminal law judgments for that matter, I think Ashit would agree with the point that I'm trying to raise here. They are very different in nature because as far as constitutional interpretations and constitutional law judgments are considered, the issue that Ashit is trying to raise, I would totally agree to whatever he said and Jacqueline said. But the issue takes a reversal role if you read criminal law judgments. We spend pages in defending something. We try to have this idea of seeing court as a nurturer, as a definer of social structures. So that is how, for instance, if we were to see the language that is being used in criminal law judgments, now here there is one aspect which all three of us never touched upon. That is the idea of sexist language, the idea of referring to instances which are scintillizing and making it more sensational. And the language used is so let's say so harming or so mentally traumatic in nature sometimes that it actually hurts the person who's involved in the process. So here, Jacqueline, I'd like to raise a certain point that in the recent past, and in fact if you were to read rape judgments from India, rape trials from India, and if you were to read from judgments, let's say from 1950s to 1950s would be quite back, let's say if we were to read it from 2000 to 2021 till now, the language that is being used is highly unempathetic in nature. And empathy, I think, is something which is missed upon while criminal law judgments are taken into account. Because here again the idea of the person who is delivering the judgment would come in, and that would also be a defining factor when you have a lot of male people in the bench and you have less female judges on the bench. So here again I think gender also plays an important role while deciding, or while delivering or authoring a judgment. That would also be a point I would like to raise here. And also at the same time, when we refer to the prosecutrix or let's say the victim involved in a particular case, when a criminal law or a criminal judgment is being decided upon, what we look upon at that point in time is a very societal perspective. Then this idea of cross fertilization, it goes away somewhere. It vanishes somewhere. So whatever Ashit was trying to say, it sublimes somewhere whenever a criminal law judgment is considered. There we actually take into, let's say, the literal interpretation more into account. We are not very creative, we are not very, and I'm not saying that creativity cannot be done in criminal law, because there are scope, there are many judgments from different jurisdictions which have shown, which have actually made, points which are relevant in the in a larger sense. So for instance, Jacqueline, recently we had a judgment on an act which is called in India as POXO judgment. It deals with someone who where children are involved in that particular act. So a judge from a particular jurisdiction, that person, that lady, now here again, she being from the female gender, and it is assumed that she would have been empathetic, had used a language which talked about the skin to skin contact as far as the idea of defining sexual assault or sexual harassment is considered, when children are considered. And she was not able to give a description which would have dealt the case in a very let's say a very empathetic and a very natural manner. And the result of which is that she was denied her elevation. So this is one step which was taken by the higher courts, and it was appreciable because of the simple reason, the language and the interpretation, because here interpretation and language go hand in hand together, was not empathetic in nature. So the idea of empathy also sometimes play a very creative role, a very important role. And criminal law judgments are another species which are different in nature, and I think they also have their own arena to be explored. So that is my point I'd like to make here.
Yeah.
Ashit, if you have to comment on anything. Yeah, Jacqueline, please.
I just think I'm very glad you raised this, and I think it's such an important point to address again when we're talking about the power dynamics, the role of gender and sexism, and as you raised, greater diversity in the legal profession is one step towards removing this sort of sexist language. But also when you talked about the example of the judge who was removed, it's not in itself sufficient to change the outcome.
She was not elevated. She was not removed. She was just not
she was
elevated to a higher position. Yes, yes.
Thank you. But it's not enough just to have greater diversity of who is in the roles. It is a mental and societal shift. And when you talk about empathy, it is an important thing. But I'm wondering, what is the root of that? Because empathy itself sounds like just an ask, like, let's be nice to each other, or like something of that aspect. And I think there's something deeper you're tapping into. And this is going to the rights, which Ashit might be able to help us out with, the constitutional rights here, of there's something in there that's like a right that the people have, the parties, and a right that the public has that is being violated with sensationalizing these situations or not dealing with them in an empathetic way. I'm not certain what exactly that right might be, but I feel there's likely some inherent human right that is not being respected in that.
Yeah. So I denote the first argument put forward by Nabeela. I think when she talks about the idea of gender perspective in the judgment writing, and again, this has a larger role to play with the identity of the judge itself. That if the judge is from a particular class, they're bound to be reflection of him or her upon the judgment, which we cannot deny. So yes, this cannot be denied. The gender ratio in Indian judges has been very less, and this is a very I think talked about fact. I recently wrote an article about this, that how India is still missing a woman chief justice of India. So after 70 years of independence, we still not able to get one. Right? We still haven't got a distinguished jurist, by the way, to become a CDI. There is a provision for that, but this still not happened. I'm still hopeful. But that tells us something about this. That so when she talked about this particular idea that is that there's lack of coordination between judges. I think there are orientation programs for judges which happen every year. So if I'm a judge from a lower judiciary, I'm going to the high judiciary. They have this orientation program every year. They are orientated regarding updated regarding all the judgments. How far the idea of empathy is a part of it, this is something I'm not very sure about. However, one thing I think Nabeela has really worked upon throughout her research, not right now but previously, is the idea of jury metric. India is lacking an idea of jury metric right now, and the idea of jury metric is the idea of evaluating a judge upon his emotional quotient, his legal quotient. So where you see how a judge will react in a particular situation. So those jury metrics are still missing in India. So our appointment elevations, the judges are happening mostly on the legal expertise, right? How far the quotient of empathy is still a consideration is something very hard to tell, right? So yes, if you're thinking from that perspective, we might not be having, because you quoted an example of the POSCO judgment which just recently came out, that there might be possibility the empathy is still missing out, but I think but that's happening at a lower level. But I think because Supreme Court of India has so much eyes upon itself, because right now Supreme Court of India is something which has been observed by everyone. So you'll find an article every week written by several academicians. One of them is me, and Nabeela also, right? So I think Supreme Court is always very alert regarding its image also. You know what? People are watching us all the time. Whatever Supreme Court quotes in a small, even an orbital line is quoted on various legal forums. So I think that is pushing a sensitivity into the judges at that time. We cannot say something bad here, or we cannot be politically incorrect here. There's a different kind of pressure being put upon them. A kind of pressure which a lower judiciary might not be having, right? So you might still find
Isn't
the
it a
Supreme
good
Court is
thing,
more.
sir?
Yes, right.
The thing you talked about, that there is a lot of
Hmm.
political pressure and that there are many eyes and they should be correct. I think
Uh,
that is important. That should be
yes.
the case.
No.
Yeah.
I do not agree to it totally. See, the idea of law is very objective in nature. You might be giving judgment which might seem morally wrong, but you cannot do something about that, because law has to be objective in nature. If the political pressure of the eyes of the media or of the legal forums is pushing you to do something going against the law, also, I cannot accept that. But what I'm talking about, the idea of the element of empathy. So if because we regard our Supreme Court of India as the most empathic institution, because it is helping with fundamental rights. So possibly all these institutions are
Hmm.
forcing it to be one. And somewhere down the line, these
Hmm.
media houses, these legal forums might not be able to are not able to capture the lower judiciary, which might not be still as empathic as compared to the Supreme Court of India. Right.
Yeah,
So
actually, I would actually agree to Ashit's point. There is a lack of legal scholarship as far as the lower courts and this court is considered. I think the Center for Public Policy, I think that is one institute, that is one think tank which is highlighted in a policy document, that there is a lack of
uh,
actual,
uh,
let's say, literature or legal scholarship on the
yes.
district courts and the high
Uh,
courts. And all these
uh,
news that we actually come to know are mostly from high courts and lower courts. So
yes.
it's just the
Uh,
Supreme Court, playing that role that it is supposed to play. So that's, yes,
So
that's a relevant point.
last year we did have a Tata Justice report. Tata Justice report talked about the judiciary in whole, from the lower to the upper. But they mostly talk about the infrastructure, the lack of judges in the lower judiciary. That there's lack of infrastructure, there's lack of money, there's lack of judges. But no one is emphasizing upon the kind of judgment being delivered by the lower judiciary. So that's a vacuum as far as academia goes. One of the prime reasons might be because there are so many judges at the lower judiciary, and you have only 32 or 31 judges at Supreme Court. It's easier to observe them as compared to the lower. So that's one of the reasons of right. So I think the more the observation, the more the pressure, the more empathy will come out. Which I think is the reason behind that.
But do you think there is an aspect of a human right that can be raised as to putting the pressure to say this kind of writing or these kinds of decisions you cannot perpetuate because this is violating a human right?
Okay, so this recently happened when I think when Nabeela gave the example of the judge who delivered the skin to skin judgment. So she was about to be permanent in that same court, but this news came out. I think the Hindus. I'm not taking the name of the paper, but this news came out that the Collegium was very happy to elevate her to be a permanent judge. Not elevate, but make her a permanent judge.
Yeah, make her a permanent. Yes.
Yeah. So this acts like a
Checks and balance.
disincentive that you cannot be delivering judgments and.
But that still sounds like a social pressure.
Yes.
Similar to what you're talking about,
And
the world's eyes.
and Jacqueline, that is the no. Apart from legal pressure, you'll have to understand, Ashit, that judgment was widely circulated via the normal social media. There was a lot of backing of the public. So Jacqueline's point is actually relevant. Had it been some other, let's assume, had that been some other court, it was a Bombay High Court. Also remember that even the jurisdiction or the geography of your court also plays an important role. There are highlighted high courts which actually come into the scrutiny after the Supreme Court, and that's one thing that has to be kept in mind. And the second thing is, it was widely circulated, widely talked about, and here comes one important point which we actually miss about: the role of feminists in actually bringing about what is wrong in the society. So that is the beauty. That is the beauty that we need to see, and that is the beauty of multiple stakeholders. When actually people start reading judgments, they actually try to understand, okay, it affects us in this manner, this is why it is crucial, these are the paragraphs highlighted, this would mean this. In fact, I think there was a very very obnoxious statement given by one of the representatives of the parliament recently, and there was a lot of backslashing as far as that comment was considered. So here the idea of awareness, as initially Ashit came brought about, and the idea of group pressure, the idea of, and here I do not mean pressure in the negative sense, I mean actually understanding your right first and then claiming your duty, because that has to go hand in hand. So I think here the idea of feminist lawyering, the idea of inclusivity, the idea of having diversity from the stakeholders is also something that actually helps you to keep a check and balance. Yes, Ashit, yeah, something to say.
Yeah, this seems like a very positive step, but we need to be very careful about this also. There are various legal forums which have their own agenda, right?
True.
And the problem with this is that people are not reading the judgment. So if you pick up a particular judgment, you take out one line out of the context and you highlight that to create a pressure, that is going to be a very wrong step for judiciary also. This will create a pressure upon judiciary to act in a democratic manner. Judiciary is a non-elected body. Do not give it under the pressure of democracy. Right? So if there are legal forums doing that, we need to be very careful. How do we see that? Right?
Okay, and you read it in the whole context.
Yes. It's not about public perception. Judiciary was never bound to be under public perception. It was bound to act as an independent body, which is working secretly but transparently. Right?
But I agree. The social pressure can be taken to an extent that goes in a direction we don't want. We want that certainty of law. We do not want a changing this way or that, just whatever the global perspective or the national perspective puts pressure on. What we want, though, is to recognize inherent human rights and respect that. And I think that aspect of diversity, of reducing sexism, of increasing equality are somehow connected to inherent human rights. And if there can be a connection with the constitutional rights, and that be the motivation and pressure, now lawyers can say, yes, the world's eye is on this, but we are demanding this because by writing the decision in this way, you are not respecting the rights of this party. And that is the problem. I think that can be the powerful way to fix and address, so you don't just have an arbitrary social pressure that sometimes might be good but could also be used in bad ways. And instead, you're getting to the root and heart of the inherent human rights to be respected before the court of law. I don't know if that's explicitly an inherent human right, but I absolutely think in any legal system we can find a connection to the inherent human rights and use that as our pressure for determining these kinds of things.
I think, Jacqueline, that is where
I agree.
feminist judgment writing also comes up. So feminist judgment writing doesn't point out the idea then and there. It actually respects the judgment. It waits for the judgment. But then you rewrite the judgment in, we call it the writing of judgment. Writing, I mean to say RIGHTING. That is, you're writing a judgment. So you rewrite the judgment in a way to write a judgment, give voices to the party who was suppressed at some point of time. And you actually look at from a perspective which the judge might, would have in some probability missed down upon. And I think it should be an exercise which should be appreciated and practiced in India as well, because we have this practice, I think, in US, in parts of, other parts of the globe, we have this, exercise, a project running. So that is something I think we can appreciate. These are the ideas of legal creativity from the stakeholders which are not on the bench. So this is also something which could be appreciated, I think. Ashit would have something to say, I think. Yes.
No, I totally agree with Ms. Jacqueline and Nabeela also. But I'm little skeptical about this from the perspective of. So see, from my perspective, the idea is quite simple, that it depends mostly on how is the CGI reacting and who is the master of the roaster. So we had the luck of having few of the greatest fundamental rights activists as being the CGI. We didn't have Krishna Iyer becoming CGI, but he was a judge in Supreme Court of India. Krishna Iyer is one of the most loved justices in India. So he delivered a lot of human rights judgment. He was always acting for the downgraded people. We had Justice P.N. Bhagwati, who was the CGI at that time, and he gave us the idea of PIL. So we are enjoying the concept of PIL even today. We had Justice Y.V. Chandrachud. So I personally feel at the end of the day, it's mostly on the CGI. And if the CGI is a cooperative individual working as a master of a roster, he'll really ensure that the judgments are much more neutral in nature. That's my take upon that perspective.
Okay. I think we can, yes, yeah, Jacqueline, we can
I
have
just,
final rounds of remarks. Yes,
I just have
Jacqueline.
one thing to say on thinking about the feminist writing. I do think there is power in showing an example of what could have been done. Because as you said, Ashit, there's training for the judges, right? And there's this idea of people are only able to follow the examples that they've seen so far. And so the more that we can bring in a creative perspective of, even if it's not a legal decision, but to say, here's how this could have been done. I think that can influence the judges and the lawyers to see, oh, okay, maybe there is a different way to consider the course and think about it.
See, also, you cannot be very rigid with institutions. When there has been evolution of human rights, first generation, second generation, third generation, I think even the judicial creativity could be something, which could be accommodative of different ideas altogether. And also at the same time, yes, criticisms also do play a very important role. So I think what Ashit is trying to say is, trying to set a tone, and I totally agree with what he's trying to put forward. The idea, especially the categorization wise, when he tried to explain, I had this meeting of minds when he was trying to translate. But then, yes, what we try to say, and Jacqueline also portrayed, is another side of the coin, which could be looked down upon, and that is the beauty of discussion, and that is the beauty of the lecture series. That is why we host this lecture, probably to have something which could bring about an idea more into the direction of research, because that is where we all stimulate our ideas and give them a fructifying point. Yes, Kim, I think we'll bring you in the picture. Unmute.
Oh, you're on mute.
Yeah.
I'm amazed at how interesting and what broad territory this conversation has taken. I think if anyone saw, well, they're going to talk about plain language, they would not have imagined human rights and feminist law and diversity in the profession and all of these really interesting points that you've all made. And this just has been a delight. Thank you very much.
Thank
yes,
you all
Farhan,
for
I
this.
think, yes, Farhan.
Can we take up two quick questions from the audience, or we end the
Yes,
session
yes,
here?
please go ahead, please. I ask the other panelist also. I'm totally
Yeah.
ready.
Can you suggest a good way for law students to take up the initiative to promote plain language? I think
I think
Jacqueline would be the
this
best
question
person.
is something directed towards Ashit. Yeah, Ashit would
Become a
also, add up to it. Yeah, Jacqueline, Ashit, please.
become a judge.
That's an excellent way. And even I'll go into the more specific local immediate next steps in your own writing. When in school and when you are a practicing lawyer, do as much as you can to practice that plain language and look for other examples, pulling from around the world, because I must say it's not one thing that any one place is doing the best. We need to be pulling from many different countries and get the perspectives, just like we were talking with those feminist rewriting examples. The more we see how to do it differently, the more each of us are going to be able to include this in our work.
The next question coming in from the audience.
I'll
Do you,
just add, Farhan,
yeah.
I'll just add the basic starts with start reading the judgment. And once you start reading the judgment, and that to Indian judgments, try to, put up your own observation of what your judgment meant to you. I think that's where it starts, because I think no one is even interested in reading judgments. Ashit and I have also faced the same when we were working together. So that's one thing which, it's a request to all the young students that are coming up. Yes, Farhan.
So the final question for this evening: do you think that the obiter dicta, that is the expressions given by the judges, must be permanently excluded from the judgment?
This question is to.
I think anyone can take it up.
Anyone answer? Ashit, you'll go ahead. Then I'll add to whatever
Yeah.
you say. Go ahead, Ashit.
I think in today's contemporary time, it is really hard to say what is
You're
obiter and
asking
what
a
is ratio.
constitutional law professor.
Yes, because I have seen judges using obiter dicta as a ratio in the next cases. So how do you really segregate between obiter dicta and ratio dicta? It's a very decent life. It's a very big question to be asked. On a very practical note, if you're looking from that perspective, you're asking the judge to be very, very robot in manner, which for a very knowledgeable person, which a Supreme Court judge is, I don't think so. He will be able to constrain himself only to the law perspective. We had judges quoting poems. We had judges quoting verses of Quran. We had judges who has been quoting from Ramayana. Right. So we cannot expect judge to be being a knowledgeable person to constrain himself only to law. So I don't think so that's possible humanly.
Yes. I would agree to what Ashit said. Also, given the diverse country we are in, with innumerable religion and then religious sects and then denominations and so on and so forth, I think every interpretation is very beautiful in its own sense. And there are issues which actually require you to delve into the very complex issues also. Sometimes that's not even the fact and issue, but there have been judges who have actually looked into other issues which are subset of that issue, and they have written the whole judgment and it has taken a different tone altogether. So there have been cases like this also. So I think permanently excluding obiter dicta would be something which even I would not promote, or I would not expect that to be practiced. That's my take. Jacqueline, if you have something to say.
Yeah, I agree with both of you, and I think there's also the aspect that when we are looking for judges to push the law forward towards a more feminist, more equal and diverse approach, having dicta is actually a powerful space where you say, this is the law and we can't do anything about this. We have to decide. But here's what we're going to explain to speak to society, to say, this is something that needs to be addressed, or this was what we were considering and why. And I think that can be a very powerful tool for promoting social justice and progress. It may not be used in that way currently everywhere, but I think that removing it completely would not benefit us.
Thank you so much for everyone who's been on the panel today. I would like to ask Kim ma'am to make a few concluding remarks before I.
Well, I think I just echo what I said earlier. This has been really fascinating, and what a great panel. Thank you all so much.
Thank you so much, Kim.
Thank
Thank you, Jacqueline. Thank you, Ashit.
Yes, so
Yes,
so
Farhan.
thankful to be a part of this.
Yes, thank you so much for inviting me.
With this, we come to the end of the session. Thank you so much for all the panel for taking your valuable time out for attending this session. This has been a great session. Thank you so much.
Thank you.